You're an employer, you finally filled a vacancy and you can't wait for the new starter to get working. But what information do you, as an employer, have to give them? The starting point, of course, is your employment contract. Ideally, a new employee should have been sent an employment contract and signed it and returned it before they actually start work, so that all the key terms and all the key conditions of employment are set out very, very clearly in writing. This is especially important if there are post-termination restrictive covenants in the contract, because they won't bind the employee unless they're expressly agreed to. They've also got to be reasonable, but that's a different story. See this video. Restrictive covenants aren't, of course, mandatory in a contract of employment, but there is a statutory requirement to give every new employee and every worker a significant amount of information from day one in writing. And it will usually appear in the employment contract, but the information can also be given in a separate document called a Statement of Employment Particulars. This is sometimes called a Section 1 statement after Section 1 of the Employment Rights Act 1996, where the obligation set out. The information it has to contain is as follows: the names of the employer and the employee or worker, the date when the employment began, with respect to an employee only, the date when their period of continuous employment began, taking into account any employment with a previous employer which counts towards that period. That normally only factors in large group companies or public sector organisations. The scale or rate of pay, or the method of calculating pay, how often payment will be made, whether it's weekly, monthly, or some other interval. It also needs to include if employees or workers have to work on a Sunday, that fact. If employees or workers will have to work overtime, has to say that. It has to include terms and conditions relating to hours of work, including normal working hours, the days of the week to be worked, whether they're variable, and if so, in what way, relating to holiday entitlement, public holidays, holiday pay, any other benefits such as childcare vouchers or a subsidised lunch. It has to include the job title or a brief description of the work. It has to include how long the employment's intended to last and what the end date is if it's a fixed term contract. It has to set out any probationary period, including the conditions and duration of the probationary period. It has to include the place of work, or if the worker's required to work at various locations, those places, and the employer's address. Where the employee or worker is required to work outside the United Kingdom for a period of more than 1 month, you as the employer have to advise the employee or worker in the principal statement of the period for which they're to work abroad, the currency in which remuneration is to be paid while they're working abroad, and about any additional remuneration and any benefits to be provided as a result of being required to work abroad, and any terms relating to their return to the United Kingdom. Since April 2020, the employee or worker has to be advised of any training they're required to complete, whether or not it's paid for by you. You've also got to give the employee or worker information about the following on day one, but it doesn't have to be in the principal statement: sick leave, sick pay, any other paid leave, length of notice of termination, which they have to give and which they're entitled to receive. And then there's a further set of information which the employer has to give to employees and workers, but which doesn't have to be given immediately, as long as it's given within 2 months of the start of employment. And this is information about pensions, any relevant collective agreements which directly affect the terms and conditions of the employment, any non-compulsory training which you as the employer require the employee or worker to complete, and disciplinary and grievance procedures. Employees and workers can also request an updated statement of particulars from you, which has to be delivered no later than a month after the request has been made. Now, be wary when you include some of this information in a contract rather than a non-contractual separate statement of employment particulars, because you could unwittingly convert a non-contractual benefit into a contractual one. What if you don't give a statement? Well, an employee can bring a claim that they've not been given the information, and if successful, an employment tribunal will decide what the terms should be, in effect giving a written contract on the employer's behalf. Now, there's no right to compensation for the employee, financial compensation, except in one situation. If they win a separate claim in the employment tribunal, such as discrimination or unfair dismissal or unpaid wages, they can be awarded an additional 2 to 4 weeks' pay. Now, that's subject to a cap. At the date I record this in March 2021, it's either £1,076 or £2,152 if they can prove they weren't provided with a compliant written statement. Now, obviously that's not a huge sum for getting it wrong, but it's irritating, and it could become huge if multiplied by several members of a large workforce all successfully bringing claims as parts of other litigation. An important note, since April 2020, most of this information now has to be given to workers as well as to employees. What is a worker? Well, it's essentially an independent contractor who works under a contract in accordance with which they agree to personally perform work or services for another person, you, but you don't count as their customer or client. So it may be the person you engage from time to time to do some web design, but it won't be the plumber who comes and repairs the office sink because you are very much their customer or client. What's the difference between a worker and an employee? Well, the main difference is that, unlike an employee, a worker can refuse to carry out any work offered to them and equally has no right to expect that work will be offered to them. Usually a worker's work won't be subject to the same level of control as an employee's. They've also got to account for their own tax and national insurance, and probably, this is unclear, probably wouldn't be transferred in a 2P transfer. A worker has no right to claim unfair dismissal, which is why you don't have to advise them about their continuous employment. But as well as being entitled to receive the information I've mentioned, they also have the right to protection from discrimination, protection from unlawful deductions from their pay, the national minimum wage, and certain health and safety protections. It's best, I generally recommend, to give workers a differently worded statement from that which you give employees, so you don't use the language which could support a claim that a worker was actually an employee. Employers, in their capacity as data controllers, have an obligation under the General Data Protection Regulation, GDPR, to provide information to their staff, whether employees, contractors, or agency workers, about any personal data you're collecting and processing. Now, there's no set out way of doing this, but the most convenient way is probably to issue a privacy notice. The privacy notice has to cover the following information: the organisation's name and contact details, the names and contact details of the organisation's representative and data protection officer, the purpose of the basic whether they will receive details of any of those contacts. You know what? I've just put it all down below in the notes for you. Now, this information has to be given to the individual when you collect personal data from them, or within a month of obtaining it if you get it from another source. If you plan to disclose the personal data to a third party, the data subject, the worker, has to be told that no later than when the information is disclosed. It goes without saying that any information relating to the management of the relationship needs to be given to the employees and workers so they're fully informed of what's expected of them. Getting them to expressly acknowledge that they've read and understood each policy is sensible, because that avoids staff denying knowledge of a policy or practice later down the line if a disciplinary matter arises. It's also sensible that if staff are dealing in information which is of commercial value to the business, you expressly draw to their attention that such information is confidential and of value and subject to the confidentiality obligations which should be in their contracts. This is because a common tactic used by people facing an injunction for misuse of confidential information is to deny they knew the information was regarded as confidential or deny they knew it was of value. Now, if you found this video useful, please do click the like button or subscribe for more Legal Explainer videos. Here are some other videos on employment law, here's one of my favourite videos, and here's where you subscribe to this channel. Thank you so much for watching. I'm Barrister Daniel Barnett. Bye bye.